morning.
Good morning. And before you get started, I just want to remind everyone that there's a pending motion for the late filed appeal that we need to make sure we cover in this hearing.
Yes, Your Honor.
Okay, thanks.
My name is Forrest Wallace. I'm a member of the Knox County Bar. I represent the appellant, Mr. Deon Young. As the court has already noted, we are before the court on our motion to accept a late filed appeal in this matter, along with a notice of appeal that I filed on the same date. To address that initially, the judgment was entered in November 22nd of 2024 in this case, and Mr. Young had retained trial counsel in Hamlin County Criminal Court. He was convicted at trial, he was sentenced, and his trial counsel did not file either a motion for new trial in the trial court or a notice of appeal before this court. I was retained outside of the 30-day window in early January of 2025 and appeared in court on the 6th of January in Hamlin County and mistakenly assumed that a motion for new trial had been filed in this matter. We discussed docketing the case. The trial court permitted us to have some additional time for me to obtain the transcripts, review them, file an amended motion for new trial, and we reset it to March. I then began working on obtaining the transcripts. We did that. We tried to file the transcripts, and the clerk called me and said, "We can't accept these transcripts. The case is closed." That got my gears spinning, and that same day I filed the instant motion that's pending before this court. So here we are, and I recognize absolutely the difficult task I have in front of me, but nevertheless, that's what I was retained to do, and that's what we are proceeding on here today. So
can I clarify some of the dates, if I could? And all of this happened before you were in the case, at least where I'd like to go here. So the judgment was entered on November 22.
Yes,
is that correct? So all things being equal, 30 days from that is December 22, which I think may have been a Sunday. Rolls over to a Monday, the 23rd. My guess is the clerk's office is closed that day. Do you know?
Not, to my knowledge, I don't know, Judge. I don't practice in Hamlin County a lot.
Oh, well, I mean, the appellate court clerk's
office.
That's where the notice of appeal would have been filed. It looks to me like it may have been either the 26th or the 27th when the clerk's office may have been opened back up, so that's probably when the notice of appeal should be filed. Irrespective of whatever happened with the motion for new trial, none of that, once again, let me say here that I don't think that's your issue, but I think Rockwell requires us to look to why the notice of appeal could not be filed within that 30-day period. So let's assume it's December 27 that that's the actual date that it should be filed under Rule 4. I don't see anywhere in the record where original trial counsel is offering, either by way of affidavit, by way of testimony, maybe on the motion for new trial or something like that, reasons why the notice of appeal could not have been filed.
The record is silent, Judge.
So with that, there doesn't appear to be any reason then that would support a good cause extension, right? Because with the extension under a good cause, we'd have to have some cause, some presence in the record. And without trial counsel's original recounting of what happened and the reason for that delay, what can we do? I mean, I understand the situation you're in when you're retained on the 2nd, you show up in court on the 6th, everyone for whatever reason thinks the motion for new trial has been filed, but that's like a week after the fact. And so I understand the delay that's occurring from that. I get that. What I think Rockwell's looking to is, though, why couldn't we file it within the original 30 days before you're in the case? And it doesn't look like I have a record that has any fact in it from which the court could make a finding. So could you help maybe on that point a bit?
Your Honor, I wish that I could be more helpful. I agree. I can see the record is silent on that issue. We did not litigate. We did not attempt to litigate a motion for new trial as was done in the Smith case.
Sure.
In Hamlin County. When all of this came into focus for me, it became apparent that I needed to get these motions filed immediately before this court.
Sure.
But I am unable to provide a reason in this record as to why trial counsel did or why she did what she failed to, or excuse me, why she did not do what she was supposed to do under the rules. And
sure.
So
okay.
I do concede that this is a very difficult position that we find ourselves in.
And once again, all of that was before your time in the case, and I recognize that. Okay.
And I do, for what it's worth, I mean, I lay this out in my brief and in the motion that I filed. I do concede that there was an additional delay, and that could essentially be placed on me to some degree for not filing it sooner, but I think after that 30 days lapse.
Well, I mean, the length of the delay is one of the Rockwell
Yes.
factors, and so if we're looking at the length of the delay, maybe as it goes, but really, I think the length of the delay is based at least in part upon why it's occurring. And so I understand why the additional delay is occurring. I don't understand from the record about why the 30 days could not have been met. So if you're 30 days plus one, we have cases that say if there's no reason in the record, there cannot be a finding of good cause. There just can't be. If there's no reason in the record for it, there just can't be a finding of a good cause. If it's something, simple negligence that doesn't rise to gross negligence, I'm not sure I'm all the way there, but I know there are cases from this court that would excuse it. But I don't even have that. So I don't have original trial counsel coming in saying, I just missed it. I'm sorry, it was the holidays, whatever, something. I don't even have that. And so I think without anything in the record, that's what is leading, I guess, to the questions I'm asking.
Thank you, Judge. And I regret that the record is not built up sufficiently to, better articulate that lapse. I still hold on to the idea that the court should grant this delayed appeal in the interest of justice. We have laid out several issues pursuant to Rockwell. Of course, we have raised sufficiency of the evidence. We have raised the sentencing issue, and arguably a more creative argument on due process as to what occurred with the firearm charge and how that played out at trial. So under sufficiency, not to belabor it, but this was a fairly straightforward fact pattern. It was a traffic stop case. My client was alone in a vehicle. He was pulled over for a minor traffic infraction. Traffic stop was conducted. That body camera footage was introduced at trial. Mr. Young was taken out of the vehicle. While he was in the vehicle, he did not have a valid driver's license, and that began a whole conversation about what else do you have? Can you show proof of this? He was working on it, I think was his statement to the officer. And then it became about the officer's requests to obtain documents from the glove box. And there was a lot of hay made about Mr. Young's movements toward the glove box, opening it barely. Perhaps it was furtive from the state's point of view. And then there was a whole issue with the key fob. And so our argument in this circumstance is that the firearm was not immediately accessible to him. There were several steps required before he could, even had he taken the evidence in the light most favorable to the state, had he wanted to reduce that constructive possession to actual possession, he still had to go through several steps, and it was not immediately accessible to him.
What several steps would he have to go through to open the glove box?
So it's in reviewing the video that was introduced at trial, it seemed to have taken a while for him to mess. It was a Porsche station wagon. And so the key to open the glove box was contained within the fob. And it seemed to take 2 or 3 minutes for Mr. Young there was some confusion about how it worked. Again, he was making statements on the scene, and I think the proof at trial showed that wasn't a car that he normally drove. It was his girlfriend's car. And so it took him a while to access the smaller key within a larger key to then access the glove box. And so our position is that, again, that it was not, of course it was not an actual possession, but under a constructive possession theory, he didn't have the ability to immediately reduce that to actual possession.
What do you make of because the state mentions the fact that he didn't open up the glove box all the way. It seemed that he took pains to make sure that it was not fully open. What do you make of that?
I understand that under a sufficiency standard that inference can play, is reviewed now in favor of the state. I don't want to concede that he had knowledge of it. It could be an inference that he didn't know it was there, and then it became apparent. I think that's how the trial court saw it at sentencing in reality. But I think Mr. Young it was a nerve-wracking situation. He did not have a valid driver's license. He may have been drinking, although he was not intoxicated. He wasn't arrested for DUI. So I think for him, And he also made some statements about being stalked. So from our perspective, it seemed like a pretty stressful situation for him.
But the jury saw and heard all of that.
That's correct, Judge.
Yeah, and they weighed all of that and made a decision to convict based on that evidence
They did, Your Honor.
with the charge of constructive possession.
That is correct, Your Honor. Pardon
I
me.
mean, how does the fact of him being, as you noted in your brief, gang stalked, that seems to me to weigh in favor of an inference that he was aware the gun was there because he needed the gun to protect himself.
It could be, Your Honor. To me, in reviewing many traffic videos, I think when people, especially in his position, someone with his background, perhaps it was nerves getting the better of him. And I think people make irrational statements all the time when they're pulled over. Now, in this case, I agree with you that it does seem to align with a concern about his physical safety. But I think once Officer Cribley kind of got him settled down, there was a long back and forth between the two of them. That was a fairly reasonable conversation, not high intensity, so to speak. The second issue I've raised, Your Honors, has to do with sentencing, which I, again, concede, even if it had been raised properly, we would still have an uphill climb. But nevertheless, in this matter, Mr. Young was determined to be a Range 3 persistent offender. The trial courts, and based on the statutory offense and conviction, the only decision to make as a sentence to serve in the penitentiary, the only decision to make was where in the range the court should fall. I agree that he was properly classified as a Range 3 offender, but our issue with how the trial court conducted sentencing was the weighing of the aggravating and mitigating factors. And again, obviously under abuse of discretion standard, it's a difficult proposition, but nevertheless.
Well, is it actually any proposition? I think what Carter said from the Supreme Court, and maybe followed up in Buys, was that that's no longer even a ground for appeal, the weighing of the mitigating and enhancement factors. So, I mean, is that even something we could consider, even if we wish to do so?
Well, Your Honor, I think the how an aggravator is applied still. I think some context of the social history of the defendant, the characteristics and the circumstances of their arrest, I still think that is valid. And
well, that's true. I mean, the presence of an enhancement factor or the presence of a mitigating factor certainly could be raised as an issue on appeal, but just the weighing of factors we all concede are present, that would not be a ground for appeal, would it?
I do concede that, Judge. Okay. But nevertheless, Mr. Young did present, although they weren't articulated specifically, there was not a sentencing memo filed. His counsel did raise many grounds for mitigation in this case. But I think if we taking the pre-sentence report, which was introduced, Mr. Young is now currently 51. It had been many years since he had been convicted of a criminal offense. And even the convictions that were used to establish the range were a series of drug convictions from the mid-1990s. And so in addition to that, he had made his own steps to rehabilitate himself after the verdict awaiting sentencing. He had gone to Buffalo Valley and had done a really intensive treatment program to work on his sobriety. There was a lot of discussion about probation at sentencing, which obviously was incorrect. But nevertheless, the pre-sentence report also concluded that he was a, quote, low risk, and they recommended minimum supervision and rehabilitation, which I realize are not even things the trial court has to consider in a sentence of incarceration, but they do hint that this is an older gentleman who, it had been a long time essentially since he'd been convicted of his last offense, which weighed again in favor of a sentence lower in the range. In my mind, the trial court pronouncing that, well, I'm starting, essentially, I'm paraphrasing, but I'm starting at the high end of the range and these mitigation factors have convinced me to lower it down to the middle, we think was an inappropriate application and contrary to the principles of sentencing. For my third issue, Your Honors, I will concede that I did get a little creative here, but we believe that the fundamental right to a fair jury trial in this case aligns with many of the other duties that a trial court has, which includes instructing the jury properly, ensuring procedural fairness, protecting the record, acting without bias. I understand that stipulation in these firearm counts, it's unsettled in Tennessee, and there's no requirement that a trial court stipulate in this circumstance. I think I'm asking for something to take a kind of a more 30,000-foot view of this situation. We're asking, we believe that the trial court at least should have done something. There were jury instructions early in the proceeding and at the very end during the final jury charge that relate to 403 and 404B evidence. But in this case, the state, in its opening statement, gets up and starts talking about aggravated assault and one or two ways that you can commit aggravated assault, not all the various ways under the statute that aggravated assault has been contemplated by by the General Assembly. And so there weren't any suggestion, any sort of guardrails that were considered really by anybody in this case, but we believe that the trial court, as the entity that's running the trial, had some best practices, I guess is the best way to put it. I think an affirmative duty may be a little severe, but we think that the trial court should have done something to at least speak up and explain to the jury if we're already getting into what aggravated assault is, the state in opening statement is getting up talking about their opinion of what aggravated assault is. And
so we're here under a plain error analysis.
That's correct.
Right? So even assuming that the appeal goes forward, this issue is still on plain error.
That's correct.
And so the fifth factor under plain error is that correction of the error is necessary to do substantial justice. And the Supreme Court has interpreted that in State versus Vance to require essentially a difference in the outcome of the trial. And Vance seems to go further than that and suggest that maybe you need to show an acquittal. Taking the Supreme Court at its word in Vance, how do we get to an acquittal?
I think that if I could go back to sufficiency again, Judge, I think the state did not present, let me put this carefully, it was unreasonable to infer an alternate timeline as to how that firearm got there, whose it was, where it came from, all those things that my client's girlfriend, Ms. Knowlton, testified about. She testified uncontested. It was her car. It was her firearm. She bought it 15 years prior. I think there was a pathway to an acquittal that the jury could have agreed that Mr. Young did not have constructive possession of the firearm. I can see that the traffic violations are tertiary in this analysis, but
well, let's get back maybe onto more comfortable ground. The second plain error factor requires you to show the presence of a clear and unequivocal rule of law that's been breached. You were very candid opening this part of the argument to say that it was a bit creative.
Yes, Judge.
If it's a creative argument, how is there a breach of a clear and unequivocal rule of law?
Your Honor, in these cases, I think for a jury to hear about for a jury to get into the specifics of a person's criminal history, rather than we have this very simple, straightforward remedy to prevent any of this from coming in. That's the whole point of stipulations. And again, I can see bifurcation is probably not required in this case because we're not dealing with similar offenses to the conviction, if that makes sense. So our argument is that in order to ensure a fair trial, that the jury should not hear, unless it's absolutely necessary, hear about the specifics of someone's conviction. And there are limited circumstances where the probative value outweighs the prejudicial nature of it under 404B. In this case, to get into the specifics of an aggravated assault, and you see it, I know I keep harping on this, but the state's doing it in an opening statement. And I think that's incredibly inappropriate to get into because it draws the jury away from, it leads the jury down a path. Again, I understand how propensity evidence could be viewed even just by a stipulation. I understand why a jury could also probably draw the same inference if we just did a stipulation that he'd been convicted of a serious violent felony. I understand that. But to get into the specifics about aggravated assault, it just invites the jury to speculate, boy, this guy must have done something really bad in the past, and he's a convicted felon, he shouldn't have a gun, and we don't believe this evidence that's being put on in this trial to defend him in this case. Even extending to Ms. Knowlton, it's reasonable to infer that they would just disregard her testimony, that she's just covering for him, basically. And so that's a long way of saying, Your Honor, that we think that the trial court, at a minimum, could have spoken up, could have done something even before trial to suggest that a stipulation, that the parties considered a stipulation, just something to be proactive to prevent exactly what happened in this case. And that's our issue. So, thank you, Your Honors.
Thank you. General Redding.
Good morning. May it please the court, Catherine Redding on behalf of the state. This court should dismiss the appeal as untimely. The defendant's deadline for filing, I would submit, was December 23rd as my reference.
It might be. I don't know if the clerk's office was open or closed, and so that's what that was the only thing that was.
Sure. Sometime during the week of the 23rd, but what is more important is not necessarily the specific date that the motion for the deadline for filing fell upon. It's the delay in filing it. Certainly, the record is clear that the notice of appeal was not lodged until February 27th, and it's the state's position that the interests of justice do not support a waiver of the timely filing requirement. The nature of the issues does not support waiver. The defendant is challenging the sufficiency of the evidence, sentencing, but more specifically the weighing of enhancement and mitigating factors, and is bringing a plain error challenge to his status, or kind of the admission of evidence of his status as a convicted felon as it relates to the unlawful possession bifurcation issues. But each of these issues is reviewed under a highly deferential standard of review, and each of the issues is also meritless. The length of the delay does not support waiver, as this court has noted. This court has declined to find waiver when dealing with a much shorter delay, and here we have 66 days.
Even 1 day or 2 days where there's no reason given in the record.
Yes, and that brings me to my next point. We know that the trial counsel did not file a motion for new trial, but as counsel has conceded, there is no information in the record as to why that motion was not filed, or even why there's no placeholder motion, there's no full motion, there's no pro se motion, there's nothing, and we don't have any information in the record.
There was a date that seemed odd, that they seemed to set a date for a hearing on a motion for new trial, but nobody looked to see that there was no motion.
Correct. That comports with my understanding.
Even this court in, don't hold me to it, State versus Manning maybe recognized that counsel could file a placeholder motion.
Yes.
Hereby comes the defendant, moves the court for a new trial, respectfully submitted, reserve the right to appeal, to amend.
Yes, and we see that fairly frequently,
right.
Where the original motion for new trial does not provide much information, and the amended is really where we get into the identification of the issues that the defendant wishes to raise, but we don't have that, and we, more importantly, don't have any explanation for why we don't have that. But if this court were to decide to waive the timely filing requirement,
the nature of the issues is interesting in this case, right? Because you have 3 issues that are raised, 2 are abuse of discretion, and 1's on plain error.
Yes.
So the nature of the issues, does that weigh in favor of accepting review?
It's the state's position that it does not weigh in favor. I think because from the state's perspective, the nature of the issues goes to kind of, is there meat on the bone? All right, is there something that this court really needs to take up? And when you're talking about sufficiency, we're talking about viewed in the light most favorable to the state. We're talking about a challenge to sentencing where it's framed as a challenge to the weighing of enhancement and mitigating factors. There's really the case law is fairly clear that that is not a basis for appeal. So does this court need to waive the timely filing requirement in order to get to these things? I think that probably the claim about the plain error claim does provide the nature of that particular issue is.
But it's still plain error, though.
Yes, it is plain error. But that issue, I think, has maybe more
I don't know what's going on today.
is more interesting to the court and could, under other circumstances, warrant waiver. But given the particular, not only is it plain error, but given the issue that would be reviewed for plain error, it does not demand waiver of the timely filing requirement here. unless the court has further questions about the state's position that the appeal should be dismissed, I'll move on for the court's benefit to the merits of the issues. Viewed in the light most favorable to the state, the evidence is sufficient to sustain the defendant's conviction for unlawful possession of a firearm. The defendant's claim focuses on the possession element here. And contrary to the position that he's taken, it's the state's view that viewed in the light most favorable to the state, a rational jury could find that the defendant possessed the firearm. And the jury was charged on both constructive and actual. But viewed in the light most favorable to the state, a jury could find the defendant possessed the firearm because proof showed the defendant was the driver of the vehicle. He was the only occupant of the car. The firearm was in the glove box. The defendant was the only person with the defendant had the key to the glove box. He was the only person who had access to the key. And when the officer asked for the vehicle registration, the defendant leaned over to the glove compartment and then, this is on video, carefully opens it, making a very concerted effort to avoid opening it all the way. And it is after multiple attempts that he finally retrieves the registration.
I mean, that's the critical fact, right? I mean, we have to have some proof that he knew that the weapon was in the car, right? And so if we didn't have that fact, it strikes me it would be a much different case.
Yes, I think that in a situation where you have a defendant who just, oh, sure, and goes over, opens it up, and poof, the gun pops out, I think we might have a different situation. But here, and we are limited to the facts that are presented, and be viewed in the light most favorable to the state, what a rational jury could conclude. And given the defendant's movements towards, even setting aside how long it takes him to get the key out, I don't think that that really means that he, okay, I guess I'll get to that in a minute, but viewed in the light most favorable to the state, what could a rational jury conclude? And given the nature of the defendant's movements and what the jury can see with its own eyes, the defendant's manner of opening the glove box, viewed in the light most favorable to the state, establishes that he knew the gun was there and that he possessed the gun.
Does the video indicate if he knew that the glove box was locked before he attempted to fiddle with the key? That's very loud.
I don't recall.
Judge Henson often asks the great questions.
Well,
And I'll say the video is in the.
We have the video, right?
You have the video, and there's also there's a. Frankly, it's not particularly clear when I looked at the photograph through the system, but there were still photographs entered into exhibit from the video that kind of showed how far the glove box gets opened by the defendant. But this court certainly will be able to review the video. But viewed in the light most favorable to the state, a rational jury could conclude that the defendant possessed the firearm. He either had actual possession when he reached in the glove box, or he had constructive possession because he did have the ability to reduce the firearm to his actual possession. And the defendant has made some arguments about, well, he didn't actually have the ability because it took him 2 minutes to get the key out of the fob and get over to the glove box. But the jury saw that and had that information and found, nevertheless, that he did have the ability to reduce the firearm to his actual possession. And I just say that this case is distinguishable from Steiner because it is not a case where the defendant and the firearm are simply in the same place at the same time. A Steiner, the firearm was under the passenger seat where the defendant was riding. There's no evidence linking him to the gun or suggesting he was aware of its presence. I mean, certainly this case is similar to Steiner in that there are no fingerprints. We don't have fingerprints to say, the defendant's fingerprints are on the weapon. But in Steiner, the defendant was not the driver or owner of the car. Obviously, that's different than what we have here. The gun's not in plain view, which is similar. The gun's in the glove box here. But there is never any movements by the defendant in Steiner to indicate that he is reaching for the gun. And that goes into the ability to reduce the possession part, not so much the knowledge. But there is a sufficient nexus to connect this defendant to this firearm, and viewed in the light most favorable to the state, which is obviously the standard that is to be applied, a rational jury could find the defendant possessed the firearm. And also, the jury heard Ms. Knowlton's testimony and disregarded it or dismissed it with its verdict. So if there are no further questions on sufficiency, I'll move to sentencing. And the state's position on this is fairly straightforward. This is a case where the trial court imposed a within-range sentence, so its decision is entitled to review for abuse of discretion. Defendants are not entitled to minimum sentences, and the defendant admits that his challenge to his sentence really is a challenge to the weighing of the enhancement and mitigating factors, and the case law is clear that that's not a basis for appeal. But in any event, the record shows the court considered the parties' arguments and that it had a reasoned basis for its sentencing decision. And the defendant hasn't really touched on this today, but any sort of challenge to the application of enhancement factor 1, which is the basis for, the court said, well, he did apply enhancement factor 1. I mean, that challenge is waived. He affirmatively disclaimed any objection. The defendant's point is, well, we don't have the judgment in the record, but he didn't object to that fact. His reliance on 4035-202 is not well placed because that really is not applicable to enhancement factors, or enhancement factor 1, and the state was only required to prove his criminal conduct by preponderance of the evidence, and that evidence came in the form of the pre-sentence report. As to the final claim, the defendant is not entitled to plain error relief. First, Judge Greenholz, as you pointed out, the defendant can't establish the breach of a clear and unequivocal rule of law. And I didn't mean to take two cases that dealt with bifurcation, but here we are. And
I was thinking we heard some of this yesterday.
Yeah, right.
I guess my first point is that the defendant is claiming that the court erred by not giving an immediate curative instruction, but this is, I'm not sure this is unusual, but maybe unusual is the right word. This is a case where the trial court gave an instruction before opening arguments telling the jury that when they heard if they heard that the defendant had a prior conviction, they were not, basically you have a 404B instruction before opening arguments, which I don't think happens in every case, and obviously the trial judges.
I don't think that typically happens, not that I'm aware of. So,
but
what did the state actually say in opening? It sounds like it went well beyond, I haven't looked at the record, of, okay, there's a prior, even just naming the prior felony. I mean, that seems pretty odd.
I'd say, my response to that is, I believe that your memory is correct. I don't believe, the state did not end with the defendant has a prior conviction for aggravated assault. It chose to explore that.
Without objection of any kind.
Correct. And then the defendant did not object below, has not raised on appeal a challenge to the state's opening argument. And I'd point out too, so not only is it waived for failure to object, failure to raise it on appeal, very clearly, arguments of counsel are not evidence. And so if we get into the actual, and oddly enough, there's a curative instruction on the front end because we have—
Before it even happens.
So I guess I would say that to the extent there's any challenge to the opening arguments, it is waived, it's meritless. And then if we just get into the claims that are actually identified in the brief, there's no breach of a clear and unequivocal rule of law because trial courts are not required to give this 404B instruction. He hasn't pointed to any case law mandating that the court give the instruction, I guess either in the middle of the opening arguments or immediately after the trial court clerk testified that the only evidence that he had an aggravated assault prior. And then we do also have the other instructions. He says that the trial court erred in failing to sua sponte exclude the prior conviction, but the state had to prove the prior as an essential element of the unlawful possession charge. To that end, this specific nature of the offense was admissible. The court couldn't just exclude it. And then he claims the trial court should have inquired about stipulation of bifurcation, but there is no clear and unequivocal rule of law requiring such inquiries. We have discussed this, but the case law is clear that there is no procedure for bifurcation, and certainly there is no clear and unequivocal rule of law requiring trial courts to make inquiries about stipulations or bifurcations. Second, the defendant cannot establish that a substantial right was affected when the Tennessee Supreme Court has said that a litigant has no constitutional right to bifurcation of issues. And third, the defendant can't show that that review is necessary to do substantial justice. And to the risk of repeating myself, the court instructed the jury at the start of trial, before opening arguments, and then during its final instructions, that it should not consider the defendant's prior conviction for propensity purposes. The jury is presumed to have followed these instructions. Second, the trial court is not required to litigate the defendant's case for him. He was obliged to either offer to stipulate or request a bifurcation, and this court can't find that it was plain error for the trial court not to do its on own. And finally, the defendant really can't show that, one, the jury would have found he had a propensity to commit violent crimes based on his prior conviction for aggravated assault, and then can show that the state jury convicted him of these driving offenses and unlawful possession based on a propensity. So that kind of, there's a two-step process, and the defendant cannot get to the end of that process. And because these are requirements and the defendant has to prove all five, his failure to establish these three mean that he is not entitled to plain error relief. If there are no further questions, the state asks this court to affirm the judgment.
Thank you. Mr. Wallace, I think you've got your rebuttal time.
Your Honor, you threw me off when I got up. I don't know if I actually moved to reserve time.
Oh, I thought you did, maybe?
2 minutes?
Oh, you did not.
So I can see that I felt that's for rebuttal time.
I obviously was out to lunch on that too already, so very well then, that'll conclude our docket. We appreciate it. We've had some really great arguments and interesting cases over the last couple of days, and appreciate everyone's help in getting this done. So we will adjourn till the November docket. Then maybe they'll get the technology fixed by then. Thanks for your patience with that.
All rise.